All right, well, we kind of talked about the eligibility tests needed for bankruptcy, specifically here, Chapter 7 bankruptcy. We're going to have actual numerical examples on the next slide as well. Chapter 7 bankruptcy, also known as liquidation bankruptcy, it's going to allow eligible individuals and businesses to discharge their debts by liquidating their non exempt assets to repay creditors. We have two tests here that are going to help us to determine if the individual or the entity is eligible. First is the monthly income comparison test. That's test number one. If the debtor's monthly income is lower than the state median income, they qualify. If not, they proceed to test two. The means test. This test calculates the debtor's disposable income by subtracting allowable expenses from their average income, then multiplying the result by 60 based on the outcome. And what are we talking about here? Allowable expenses. This is going to be a normal amount of rent, right? A normal amount of gas, normal amount of groceries, expenses that are allowable, whereas your payments on a new pool or expensive, lavish dinner parties, those are not going to be allowable expenses. If less than the minimum income, then Chapter 7 is allowed. If more than the maximum income, Chapter 7 is not allowed. And then in that case, if Chapter 7 is not allowed, you can actually consider Chapter 13, or the bankruptcy case will be dismissed. If between these amounts, Chapter 7 is allowed. If less than 25% of unsecured claims are not entitled to priority payment. Again, we'll kind of see an example of how this works. And any amounts you need to know, again, will be in the resources linked below. Who can file here? Well, Chapter 7 bankruptcy is not available, and you may think this is kind of random, but hey, this is the tax code. It's built upon by decades of history and special interest groups and those who get certain privileges and those who generally don't. So Chapter 7 bankruptcy, not available for railroads, savings institutions, insurance companies, banks, and small business investment companies. That's just something to memorize. That's the rules as well. Filing may be voluntary, initiated by the debtor, or involuntary, initiated by the creditors. We'll obviously dive into that a lot more later on as well. Requirements for individuals. Now, before filing, individuals must undergo credit counseling within 180 days and complete a financial management course after filing. That is keeping you in check, making sure you're learning from this so that you hopefully don't come back to this process. Now, under Chapter 7 of the Federal Bankruptcy Code, the debtor is going to be relieved of any personal liability to the judgment creditor, even when there is no bankruptcy estate. Lastly, spouses may file jointly to avoid duplicate fees. All right, let's see a nice little example here. Well, let's assume that a debtor named John is trying to determine if he qualifies for Chapter 7 bankruptcy. He lives in a state with a median monthly income of $4,500. First off, we have test one. Let's compare John's income. John's monthly income is $4,200, which is lower than the state median income. Therefore, he qualifies and does not need to proceed to test two. But let's assume another debtor named Jane also wants to file for Chapter 7, but has a higher monthly income. Now we're going to do test one, and it looks like Jane's monthly income is $5,000. That's going to be higher than the state's monthly median income, which is $4,500. As such, she has to proceed to test two. In test two, this is the means test. Jane's average monthly income is $5,000. After subtracting allowable expenses of $3,500, her disposable income is $1,500. Next, we multiply her disposable income by 60, so 1,500 times 60 there gives us 90,000. Now, based on the outcome, since $90,000 is more than the limit, which in this case is $13,650, and again, this will be determined for you in the question. You'll have to memorize this as this does change year to year. Chapter 7 bankruptcy is not allowed for Jane. Jane should consider Chapter 13 bankruptcy or dismissal. This is the process. Not too wild, but also not too heavily tested. Just get familiar with it. You'll be good to go. All right. Here are claims that are actually discharged in bankruptcy with some examples as well. These are going to be beginning with unsecured portions of collateralized debt. So an example here is a debtor's car is repossessed and the sale of the car does not cover the entire loan balance. The remaining unsecured portion is dischargeable. So what do we mean by that? You owe someone $10,000. They take your car, they sell your car, and they get $6,000 from it. So you still owe them $4,000. Well, that remaining portion is dischargeable. That $4,000 will be wiped away. Again, we'll also talk about claims that are not discharged. And as I mentioned, oh, you're going to love it. Spoiler, student loans, you're stuck with those until you die. And then they'll still try to come after your family after that if they're not paid at that point. Unintentional torts, well, if a debtor accidentally causes damage to a neighbor's property, resulting in a dischargeable debt. This is, again, something that you will be discharged. That's an unintentional tort. Now we'll see if you go and you purposely smash your neighbor's car. That is going to likely not be able to be discharged in bankruptcy. Breach of contract. A debtor breaches a contract with a service provider, resulting in a dischargeable debt. So let's say you're not paying your utility bills, your internet bill. That's an example of what we'd see there. Contract claims. A debtor defaults on a credit card debt, which is a contract claim, and that would be dischargeable as well. Debts arising from negligent conduct. A debtor's negligence causes a car accident, and the resulting debt is dischargeable. Kind of similar to the unintentional tort, negligent conduct. I know they're different, but think of them in the same vein there. And then lastly, debts owed to secured creditors beyond the value of the collateral. So a debtor's home is foreclosed, but the sale proceeds do not cover the mortgage balance. The remaining debt is dischargeable. Pretty much kind of similar to point one. Point 1 and 6 go hand in hand. 2 and 5 are going to go hand in hand. And you know what? We'll loop 3 and 4 in there hand in hand as well. Don't leave them out. Don't leave them hanging. Let's keep moving along. Nothing too wild here. Just some good examples. Make sure you are familiar with what claims will be discharged in bankruptcy and what will not. All right. Here are claims that are not discharged in bankruptcy. We have got examples as well. Now, any claims due within 3 years of bankruptcy. So let's say a debtor failed to pay a court judgment issued 2 years before filing for bankruptcy. That makes the debt non-dischargeable. Fraud, gotta love it. So if you provide false income information on the loan application, leading to a non-dischargeable debt. So if there's any fraud involved with the debts that you're trying to get discharged, they're not going to get discharged. Alimony and child support, well, you gotta pay for the child support. You gotta keep the children alive. Do it for the children, as I kind of alluded to in many cases throughout other lessons. Usually it's like you don't mess with the child support. So a debtor owes overdue child support payments, which are not dischargeable in bankruptcy. Taxes, a debtor has unpaid income taxes from the previous year. These are non-dischargeable. You also don't mess with the IRS. The IRS is going to get their money one way or the other. So we're going to see these kind of, I'll call them the hard asses. All of these instances of they're going to get their money. They don't care if you're going through the bankruptcy process. Willful and malicious injury, intentional torts. If I cause harm to another person and I'm being sued for damages. Now, again, we saw in the previous slide how if it was an accident, and obviously that would be determined by the courts, but if it's determined to be an accident, it's dischargeable. If it is going to be malicious or something like that, if I purposefully hit someone, or if I took a hammer to their car and caused damages that way, that is non-dischargeable. Educational loans, oh yeah, debtor has outstanding federal student loans, which are generally non-dischargeable. I mean, hey, with the way things are going every day, I feel like that's in the news. So who knows? That may be updated at some point, but as of now, that's what we're looking at. And lastly, debts undisclosed in bankruptcy. A debtor fails to list a personal loan from a friend in their bankruptcy filing, making the debt non-dischargeable. This is kind of an accountability point. So if you just straight up forget about a debt and you don't include it in the filing, well, that's on you. You should have included it. Because you did not include it, whether it's a loan to a friend, or if it's any of the other ones. Let's say you have a debt that would normally be discharged, but you forgot to include it. Sorry, that is non-dischargeable now. All right, reaffirmation of discharged debts. What is that? Let's talk about it. Let's run through. Reaffirmation of discharged debts refers to a voluntary agreement between a debtor and a creditor in which the debtor agrees to remain liable for the debt that would otherwise be discharged in bankruptcy. You're thinking, this is crazy talk. You're a crazy person. You're getting a discharge. Why would you still want to pay that? Well, there are reasons for that. A debtor may choose to reaffirm a debt to maintain good relations with a particular creditor, especially if you're going to be, conducting business after this. You're going to want to possibly do business with them again. If you're talking about with a local bank to keep specific collateral, such as a vehicle or home, basically saying, okay, yeah, you could get out of this if you wanted, but because, again, you want to maintain positive, solid relations with whoever that is, again, you're going to want to, maybe you just know them and you don't want to screw over someone in your local community, something like that. Many reasons, but you can choose to reaffirm the discharged debt. Now, for a debt to be reaffirmed, the debtor and creditor must enter into a reaffirmation agreement before the bankruptcy charge is granted. The agreement is subject to the approval of the bankruptcy court to ensure that's in the best interest of the debtor and does not impose an undue financial burden. So also, again, kind of the court saying, hey, is this really the best idea? Kind of stepping in like a parent saying, let's think about this. Should we really affirm this debt? Now, it's important to note that reaffirming a debt means the debtor will continue to be legally obligated to pay the debt even after the bankruptcy case is closed. If the debtor fails to make the agreed upon payments, the creditor may pursue collection efforts, including repossession or foreclosure of the collateral. So maybe this is not a good idea. Again, it totally depends on your personal situation, or hopefully not you. I hope you never have to go through this. But the individual's or entity situation, debtors should carefully consider the potential consequences of reaffirming a debt and consult with a bankruptcy attorney. Basically, yeah, just think about it. Does it make sense to do this? Maybe it does, maybe it does not. Here, nice little bankruptcy chart. These are entities that are not eligible for liquidation and entities that are not eligible for reorganization. So we know that liquidation is Chapter 7, reorganization is Chapter 11. So these would be those entities that are not eligible for Chapter 7. These would be entities that are not eligible for Chapter 11. We could talk about the rationale, the history of all this, but I think it'd be a lot easier to just memorize that and move on. I think you agree with me as well. Hey there! Are you ready to not only pass your CPA exams, but truly understand and enjoy the material while studying? I know it seems impossible, right? Especially to enjoy the material? We'll do it together. Tap into the power of CPA.examprep.ai, where we've got personalized quizzes, multiple choice questions, memorization guides, flashcards, simulations, all tailored to your learning. Our adaptive study planning puts you on the fastest path to success and lifts you back up if you fall behind. Avoid wasting your precious time and money attempting an exam with a low chance of passing, because who wants that? We want to get you through this process as quick as possible. Our exam readiness prediction lets you walk in with confidence, knowing that you're prepared for success on exam day. Thankfully, there's no payment method needed to get started, so why don't you come join us? Visit cpa.examprep.ai and let's achieve your exam success together.